House to Home, presented by RE/MAX Diamond Realty.
This is a continuation of our fascinating discussion last week in which Liz and Gina from RE/MAX Diamond Realty Guam told you how you can actually claim property that has been willed to you. So if you missed the first one, go back on our YouTube channel. You can check that out under the House to Home playlist. Liz is here right now, flying solo today. Where's your partner?
She had an important showing she had to go to. One of our agents got sick, and of course, jolly on the spot, she has to bail and help them out. Well,
we hope that one of your agents, she is on the mend right now and she gets better. And we are glad to have you here because we just started really to ramp up this conversation. This is a complicated issue because you said many times, you're not accountants, you're not lawyers, even though your job is to facilitate getting the customer in that part. But if I have gone to the extent already of saying, okay, property was willed to me, I know it's in my name, I'm starting to file the papers and everything like that. What are we looking at, Liz, in terms of like timetable, turnaround?
Remember that probate does take a while, and we've explained to people that when you do, everything is subject to the court approval. So your attorney more than likely will have to file all the paperwork and send it to the court to get the proper processing. We usually say like 3 to 6 months. It could be longer. It just depends on, and just remember, if an attorney is filing all the documents in court, he needs all the heirs notified and everyone on the same page because he needs all that information to file the documentation. If one heir is missing, then it kind of complicates it. But again, they need every heir to be reflected on the documentation he puts together.
Okay, now far be it from me to editorialize, but I'd like to inject myself into this hypothetical situation for a minute, right? I realize if I have property coming to me by way of will, that's a very generous gift, and then I make the claim as we were talking about last week and everything. It's probably smart of me to that point to make my own will to figure out who it goes to. But like right now, I mean, I'm single and I have no children. I have no heirs. If I am going to make a will and say, these are my wishes and my intent on what to do with this property, and what are my options there?
I mean, you could give the property to me,
there you
write
go.
out the documents and say,
I'll have my people call your people.
My will states I'll give this piece of property to Liz Duenas. And when I get that, I can't really do anything. It just tells your intent. And as we mentioned in the last show, then I'd have to take that to an attorney, and then he'd have to file the paperwork to show that. Now, if you have siblings, they could dispute that and say, we're not in agreement. Why is Liz getting the property? So again, that involves attorneys and a court process.
And that's when it gets really, really sticky, right? Because I say, hey, I'm giving it to my friend. She's someone who's learned and a professional in this industry. I trust her to do the right thing with my property when I'm no longer walking the earth. But do familial ties actually override that?
Well, like I said,
because I may have made a bad call.
If let's say you're not, they could say, were you of sound mind?
Right.
They could dispute it, and they could always bring up something that, what if they said, well, Jason told me he was going to give me the property first, and where did you come from? I'm supposed to get it. Now on Guam, we get that, where an individual was told by his grandmother, you're getting this piece of property. But then when grandma passes, the children, maybe there's 5 of them, they all want to claim the property. It was verbal, it wasn't in writing. Now, families can say, oh yeah, I remember grandma saying they were going to give it to you.
Yeah, prove that.
But prove it. It wasn't anything in writing. And then in the end, the 5 siblings decided, well, let's get the property because we're entitled to it, we're the remaining heirs, and let's sell it and split the monies. And that happens a lot. But again, if grandma tells you, I'm going to give you, Jason, this property, say, grandma, write it down and put it in the form of a will. Or what grandma could do is say, I, Grandma Liz, hereby quitclaim my interest in this property to Jason. So that's another way, and in the form of the quitclaim. Now, I tell people, if you're transferring title, it's best not to just do it yourself. I would say go to an escrow company because they have all the forms, they know the process, and you want to have it done right. You want to make sure that if you record a piece of document, your name appears later that Jason Salas is the owner of this property, and there's no question, because all the proper documentation was filed.
Here's another hypothetical, right? What if I indeed will property to you, right? Something happens to me, I go in the witness protection program, I change my name and move to Canada, right? But I give property that I now own to you, but I actually put in my will, we have a friendly relationship, I am giving my property to her. Can I actually say, though, it is only to be used for the purpose of residential property?
That's covenants and restrictions.
Yeah.
So
I would like my family's
yes,
legacy and like our property.
Yes.
I don't want you turning this into like an apartment building or something.
So usually when we are selling property, we always ask, like in a particular name, are there covenants and restrictions that run with the deed? When I say covenants and restrictions that run with the deed, for example, if you're giving me property and it's recorded and it says Liz is to do A, B, C, D with this property, and if it doesn't conform with that, of course it has to apply with the zoning laws. And if it doesn't conform, then I'm in violation of the covenants and restrictions. If I were to sell that property to someone else, we have to notify the buyer that covenants and restrictions run with the deed, meaning it's recorded, you have to follow that.
Okay, I'm feeling a lot better about this topic now. Admittedly, this was terrifying me when we first started talking about this 2 weeks ago, but I feel a lot better about what decisions I can make and now what questions I can ask. So thank you very much.
You're welcome.
Okay,
but advise everyone.
Yes, please.
Talk to your attorney. We're just the real estate agents. We're relaying what information that we've dealt with our different clients. We're not attorneys. You have to, of course, seek legal advice if you need.
Real quick before we go, are there any attorneys I could see, or there are
There's
attorneys
a
on ground
batch
that
of them
specialize
that
in real
specialize
estate?
in real estate,
Okay,
yes.
there are those kind of
Yes,
attorneys. Okay,
yes.
good to know. All right, thank you. We'll
You're
see you next week.
welcome.
And we'll see you after this break.
Closed caption.